In a courtroom where every word matters, one man walks in believing the law doesn't apply to him. Facing a debt claim from Midland Credit Management, the self-proclaimed sovereign citizen refuses to accept official mail, insisting the court is simply making him an offer to contract. Calm but firm, the judge explains that ignoring legal documents won't make the case disappear, it could actually seal his fate. As the hearing continues, confusion turns into confrontation. The defendant claims he doesn't understand the debt, the process, or even why he's standing before the court. Instead of presenting clear evidence, he relies on complicated phrases, unusual filings, and arguments that sound official but fail to follow real legal procedure. The judge repeatedly warns him that the courtroom has established rules he cannot rewrite, and urges him to seek proper legal advice before things get worse. Given another chance, the court even orders the plaintiff to resend the full information packet, making it clear this is his opportunity to respond correctly. But instead of submitting a proper defense, the defendant files a strange motion packed with confusing legal jargon and statements that accidentally support the very claim he's trying to fight. With deadlines missed and no valid evidence provided, the judge reviews the filings and reaches a decisive conclusion. What began as a stubborn refusal to cooperate ends in a swift legal victory for the plaintiff. The case becomes a powerful reminder that misunderstanding the law, or trying to outsmart it, can come with real and immediate consequences. This courtroom moment isn't just about one debt dispute. It reveals how refusing to follow legal procedures can waste time, complicate justice, and ultimately lead to outcomes that could have been avoided. And as the final ruling lands, one truth becomes clear. In court, belief doesn't matter, only the law does.
Versus Kevin Hurst, date and time for pretrial, no appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I opened written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me. She was
I wasn't finished. I wasn't finished. She
All right,
cut
I'm going to
me
mute
off.
you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
gonna
I was
have this.
still talking.
This is not a clown show.
Oh
You will
my
speak
goodness.
one at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes,
Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have.
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
They are claiming that this debt belonged to me, but they have to produce all the proof and verify that this debt belongs to me.
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. I got a question. Should they have sent me some?
The courtroom was quiet, the kind of heavy silence that makes every small sound feel louder than it should. Papers shuffled softly, a chair creaked, and the low hum of whispered conversations faded as the judge took his seat. Everyone sensed that this hearing wasn't going to be ordinary. The defendant standing before the bench wasn't just challenging the charges against him, he was challenging the entire authority of the court itself. From the very beginning, it was clear the man had no intention of participating in a normal legal process. Instead of answering basic questions, he began delivering a rehearsed speech filled with legal-sounding phrases, unusual terminology, and confident claims that the court had no jurisdiction over him. He insisted he was a sovereign citizen, separate from the laws of the state, and therefore not subject to the charges. The judge listened calmly at first, his expression neutral, giving the defendant space to speak. Years of experience had taught him that patience often reveals more than interruption ever could. The man continued, growing more animated with every sentence, explaining that he did not consent to the proceedings, that he was appearing only under protest, and that his name written in capital letters represented a corporate identity, not his real self. Some people in the courtroom exchanged glances. Others tried to remain expressionless, but the tension was obvious. This wasn't the first time the judge had heard arguments like these, but the confidence with which the defendant delivered them suggested he truly believed they would dismantle the case against him. The judge finally leaned forward slightly and asked a simple question, bringing the speech to a pause. He requested the defendant to confirm whether he understood the charges and whether he intended to enter a plea. It was a straightforward procedural step, one that happens in courts every single day. But instead of responding directly, the defendant doubled down. He repeated that he did not recognize the authority of the court and demanded proof that the judge had lawful jurisdiction. He spoke about constitutional rights, contracts, and obscure interpretations of legal theory, insisting that without his consent, the proceedings were invalid. For a moment, the judge remained silent, looking at the man over his glasses. Then, with a slight shake of his head, he calmly explained that the court's authority does not depend on a defendant's personal agreement. Jurisdiction, he clarified, comes from the law itself, not from individual approval. His tone was patient, almost instructional, as though he were explaining something basic to a student who had misunderstood the lesson. The defendant, however, refused to accept this explanation. He interrupted repeatedly, trying to regain control of the conversation, speaking louder and faster. He insisted that the judge was ignoring the real law and claimed the case should be dismissed immediately. That's when the moment happened that would later spread across the internet. The judge let out a brief, genuine laugh. It wasn't cruel or mocking, more the reaction of someone hearing a claim so fundamentally flawed that it caught him off guard. The sound broke the tension in the room instantly. A few people shifted in their seats, surprise. The defendant looked stunned, clearly not expecting his argument to be met with amusement rather than concern. The judge quickly composed himself and explained, still calm, that the arguments being presented had been raised many times before in courts across the country and had consistently failed. He clarified that while everyone has the right to defend themselves, repeating legally unsupported theories would not stop the case from moving forward. The defendant tried again, this time insisting that he was not the person named in the charges and that the government was attempting to prosecute a legal fiction. He spoke as though this distinction alone should end the entire process. The judge responded with steady clarity. He explained that the court recognizes the individual physically present, regardless of stylistic variations in how the name appears on documents. He reminded the defendant that refusing to engage with the proceedings would only limit his ability to defend himself effectively. Still, the man persisted, repeating variations of the same arguments. He demanded that the judge provide an oath of office on record. He questioned the courtroom's flag. He claimed that unless certain documents were produced immediately, the hearing could not continue. Each time, the judge answered briefly and directly, steering the conversation back to the essential issue, the charges and the plea. His patience was evident, but so was his firmness. The courtroom was not a debate stage for abstract legal theories. It was a place for resolving actual cases under established law. As the exchange continued, the contrast between the two became more striking. The defendant relied on memorized phrases and rigid talking points, while the judge relied on clear reasoning and procedural consistency. One spoke in declarations, the other in explanations. Eventually, the judge made it clear that the court would proceed whether the defendant consented or not. If the man refused to enter a plea, the court would enter one on his behalf, as required by procedure. This wasn't a threat, just a statement of how the legal system functions. The realization seemed to unsettle the defendant. For the first time, his confidence faltered slightly. He paused, looking around the courtroom as though searching for confirmation that his strategy should still work. But the silence offered none. The judge then explained, in simple terms, that the legal system is built on rules designed to ensure fairness for everyone. Those rules apply equally to all individuals, regardless of personal beliefs about sovereignty or jurisdiction. He emphasized that the defendant still had every opportunity to challenge the evidence, present arguments, and defend himself, but only if he participated within the framework of the law. The atmosphere in the room shifted. What had begun as a tense confrontation now felt more like a lesson unfolding in real time. The judge's calm approach highlighted the difference between confident claims and legally valid arguments. After several more attempts to redirect the conversation, the judge moved the hearing forward. The procedural steps continued, and the case progressed despite the defendant's objections. The system did not collapse. The courtroom did not lose authority. Instead, the process carried on exactly as designed. For those watching, the moment served as a powerful reminder of how courts actually function. Real legal authority doesn't come from dramatic speeches or clever phrases, it comes from established law, precedent, and procedure. And while anyone can question the system, simply declaring independence from it doesn't make its rules disappear. The judge's brief laugh, which might have seemed small at the time, symbolized something larger. It reflected the gap between internet myths about the law and the reality of how courts operate every day. In that single reaction, viewer could see both the human side of the judge and the enduring stability of the legal process. As the hearing concluded, the defendant's earlier confidence had noticeably softened. Whether he fully accepted the court's authority or not, the outcome made one thing clear: the legal system moves forward based on law, not personal declarations. And for viewer online, the clip became unforgettable, not because of shouting or chaos, but because of that simple, genuine moment when the judge laughed, calmly explained the truth, and carried on with the law exactly as it was meant to be applied.
Sir,
To verify that.
sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written requests for discovery, you have a right to do that too. You can send written interrogatories, requests for production of documents, and requests for admissions. Same as her.
Alright guys, so apparently this idiot actually accepted the packet. I mean, I just called him an idiot, but you know, maybe his last two brain cells decided that might be a good idea. But now, he's gonna be back in his next appearance. In this appearance, you're just gonna have to see what he says. I mean, it's just so stupid the judge actually laughs at him to his face. But with all being said, let's go ahead and dive into the next appearance here.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter, knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Okay, yeah.
you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side. The court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of general issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.